We're joined by Michael Borley. He's a professor at the College of Law at Florida State University. Also a member of the National Task Force on Election Crisis member. Thanks for giving us your time today.
Thank you. Happy to be here.
On Capitol Hill over the last couple of days, something called the Electoral Count Act has been discussed greatly. Could you tell the audience what it is and what its importance to actually determining who the president of the United States will be?
Sure. So the Electoral Count Act is a federal statute that was passed in the late 1800s to govern the very last stages of presidential elections, right? When voters go to voting booths on election day, in most states, they press a button or fill out a ballot with the name of a presidential candidate on it. Under state law, they're not actually voting for that particular candidate. So if you press the button for Joe Biden or fill out your ballot for Joe Biden, for example, you're not literally voting for Joe Biden. Instead, you're voting for the slate of Democratic presidential electors that was nominated by the Democratic Party of whatever state you're in. Each state then tallies the results of its election. 49 states do so on a winner-take-all basis. So whichever candidate gets the most votes in that state wins all of that state's electors. 2 states go congressional district by congressional district. So they'll tally the votes up separately within each congressional district, and whoever gets the most votes in that district gets the presidential elector for that district. And then the electors meet in December separately within each state on a date set forth in federal law, cast their electoral votes, determine which presidential candidate they're actually going to vote for. And many states actually have state laws restricting who electors are able to vote for, requiring them to cast their vote in accordance with the outcome of the popular vote in that state. And then those electoral votes get sent to Washington, D.C. Pursuant to Article 2 of the Constitution and the 12th Amendment, Congress then meets in joint session. So the House and the Senate actually meet together in the same room in a joint session presided over by the vice president. And these electoral votes are counted and tallied. And whichever candidate gets a majority of electoral votes, or to use the more specific constitutional language, receives electoral votes from a majority of electors appointed, becomes the president. And so the Electoral Count Act is the federal law that was passed in about a decade after the Hayes-Tilden election of 1876, when we were basically on the verge of Inauguration Day without knowing which of competing slates of electoral votes would be counted. Congress passed this law to regulate that joint session, to provide procedural and some substantive rules to govern that joint session at which the electoral votes are counted and tallied.
You mentioned the 12th Amendment, and in part it reads, the electors shall meet in their respective states and vote by ballot for president and vice president. They shall make distinct lists of all persons voted for as president and of persons voted for as vice president, and the number of votes for each transmit that's sealed to the seat of the government of the United States, directed to the president of the Senate. The president of the Senate shall then, in the presence of the Senate and the House of Representatives, open those certificates, and the votes shall be counted. The person having the greatest number of votes for president shall be president. What happens that in the original law, as this process goes, if there's a dispute, much like we saw back from the most recent election?
So the Electoral Count Act has different sets of rules depending on how many slates of electors, or I should say, how many potential slates of electors Congress has received from a state. When there's only one slate of electors from a state, Congress's only choice is, do we count it or not count it? And the Electoral Count Act is heavily tilted in favor of counting it. The default rule is that where you only have one slate of electors from a state, Congress has to count it unless both chambers are able to agree that those electoral votes were not regularly given by lawfully certified electors pursuant to the ECA. And that's actually one of the issues with the statute, that these two key terms, what does it mean for electoral votes to be regularly given? What does it mean for electors to be lawfully certified? These terms aren't defined by the ECA itself. There's not a clear explanation in the legislative history specifically setting forth what they were intended to mean. And so part of the motivation for the ECA reform effort is to try to clarify those terms, or in some substantially larger proposals would be to even just completely reform the process, get rid of those terms, and establish even stricter requirements for what Congress is able to do. Where
Again,
there's
go ahead.
where there's competing slates of electors, in contrast, where it's not just a matter of, is Congress going to count what the state submitted, then the Electoral Count Act has more complicated procedures where the state has to, where the joint session of Congress has to determine, are one of these slates entitled to safe harbor status, which you might remember from being one of the major issues in Bush v. Gore. If multiple slates appear to be entitled to safe harbor status, Congress has to see if both houses can agree on which one to actually accept. If none of the slates are entitled to safe harbor status, then the chambers of Congress have to determine if both chambers can agree on which one under state law was actually the lawfully appointed slate of electors. So things get more complicated when there are multiple slates submitted from a state, which makes the initial threshold question of what counts as a potentially valid slate of electors very critical. And that becomes another one of the main focuses of ECA reform.